Hey folks, Attorney Andrew Branca here from Law of Self-Defense, currently still attending the S12 conference put on by carrytrainer.com out in the Nashville area. But I do have a short Law of Self-Defense show I wanted to record for all of you. This is a pre-recorded show, not live, because of the poor internet I have here. I can't really live stream. It doesn't work. But it involves a number of scenarios currently in the news and other scenarios having been in the news in the past involving the use of chokeholds, specifically carotid chokeholds. So chokeholds that don't impair breathing but constrain the carotid arteries and induce unconsciousness by limiting blood flow to the brain. The use of chokeholds by both police and by civilians in defending themselves and others from erratic criminal predators. And suddenly those predators die. And the question is whether or not the use of the chokehold in the manner it was used could reasonably have been foreseen to risk death of the subject of the chokehold, or whether there's a different explanation, not involving criminal liability on the part of the person placed in the chokehold, that could explain these unanticipated deaths. And with that out of the way, I'll go ahead and start the launch of today's show. All right, folks, welcome back. Before we jump into things, I do, of course, have to mention the sponsor of today's show, which is none other than Law of Self-Defense itself, our best-selling book, The Law of Self-Defense Principles. Check it out on Amazon. It's 5-star rated, something like 1,500 reviews, but don't buy the book on Amazon. They'll charge you for the book and shipping and handling. We only ask that you cover the cost of shipping and handling. We eat the cost of the book. So we give you the book for free, and you can get your own copy of the best-selling Law of Self-Defense Principles, a real physical book, not just a PDF download, shipped to you by going to lawofselfdefense.com/free book. This is the handbook that teaches you how to be hard to convict after you've been compelled to use force in defense of yourself, your family, your property, and it's written completely in plain English. Again, you can get your free copy at lawofselfdefense.com/free book. So I wanted to talk about chokeholds. So this very week, as I write this, in Wisconsin, a man named Michael Mattioli is being tried for murder, the murder of another man called Joel Acevedo, on the grounds that Acevedo died as a result of a chokehold placed on him by the defendant Mattioli. And Mattioli claims he applied the chokehold for the sole purpose of self-defense and only to the extent necessary for self-defense. And yet this week he was on trial on a charge of murder and looking at spending the rest of his life in prison. Now, I have to add that just minutes ago, the jury in that trial came back with a not guilty verdict. So, fortunately for Michael Mattioli, but until this was updated literally 30 minutes before I recorded this show, breaking news that Michael Mattioli was found not guilty of homicide in the choking death of Joel Acevedo. Nevertheless, he was put at risk, at peril of a trial. Of course, we have another famous choking case, this of Daniel Penny in New York City. Penny placed drug addict Jordan Neely in a purported chokehold on May 1st of this year in defense of himself and other passengers on a New York City subway car who felt threatened by Neely. In fact, this New York Times article, I don't have time to read through it, but I can tell you that it's full of testimony, sworn testimony from other passengers on the subway car who say under oath that they were in fear of harm from Jordan Neely. Now, Neely died while he was being restrained by Daniel Penny, and Daniel Penny is now charged with second-degree reckless manslaughter and criminally negligent homicide. And earlier this year, many of you will know, I was a legal consultant and expert witness in a trial here in Colorado where the defendant was being tried for murder, reckless manslaughter, and criminally negligent homicide after he placed another man in a chokehold in self-defense, and the other man died. Now, I was, of course, consulting for the defense, and we did secure that defendant's acquittal, with the jury telling us afterwards that my expert witness testimony, and I was the last witness they heard before closing arguments and deliberations, that my expert witness testimony was key to their decision to acquit. Now, all these cases with chokeholds, but chokeholds are applied in Brazilian jiu-jitsu gyms all around the world, many thousands of times a day, and nobody in the gym dies. Indeed, a properly applied chokehold is unlikely to cause anyone even serious bodily injury, much less death. And the reason for that is that a properly applied carotid or vascular chokehold, as opposed to a respiratory chokehold across the larynx, a properly applied carotid or vascular chokehold is sustained only as long as necessary to either cause the person being choked to stop being a threat in the gym, he would just tap out, or until a real world threat loses consciousness. And that process takes only 6 to 10 seconds. Now, that said, if a chokehold were held for as long as a minute, that same chokehold could cause brain damage. And if held for 3 minutes, that same chokehold could be expected to cause death. So what really happened in the case of Mattioli in Wisconsin, just acquitted 30 minutes ago, or Daniel Penny in New York, whose trial is still upcoming, or my defendant in Colorado? Did those 3 men really maintain a chokehold for more than the 3 minutes that would be required to cause death? In all 3 of those cases, by the way, the prosecution has argued that the defendant charged had held their chokehold for as long as 10 minutes. Now, I practice Brazilian Jiu-Jitsu. I've personally been choked, and I've choked others in the course of my studies. And based on my personal experience, it's simply not credible to believe that someone actually held in place forcefully another person in a sustained chokehold for 10 plus minutes. For one thing, why? The person choked would certainly be dead within 5 minutes, and there'd be no need for further choking. For another thing, it would be exhausting. So I suspect there's something else at play in these and other instances in which chokeholds have been associated with death, under circumstances in which the person who placed the choke was utterly shocked that the death occurred. In all 3 of these cases, in Wisconsin, in New York, here in Colorado, the person charged stated that they were acting in self-defense and applied the choke only as long as necessary to control the aggressor they were defending against. Indeed, Penny in New York City argues that he never really applied choking pressure at all, but he merely had his arm around Jordan Neely's neck as a form of control until police arrived. If you control someone's head and neck, you really control their whole body. So if these deaths were not caused by predictable outcome of the chokehold, what else could be happening here? Well, all 3 of these men who died in these cases, and in many other similar cases, I'll talk about some others in a moment, had something in common. They all had incredibly frail physiologies, largely due to a long-term addiction to alcohol, to a variety of drugs, or both. In the Wisconsin case, the trial just wrapped up with an acquittal half an hour ago. The victim, Acevedo, was found at autopsy to have had alcohol, cocaine, and THC, marijuana, on board his body. In the New York City case, Jordan Neely was well known as a lifelong drug addict. In the Colorado case I helped defend, the victim was a lifelong alcoholic with existing cardiovascular disease as a consequence of that lifelong alcoholic behavior. The well-characterized safety of carotid chokes in BJJ gyms worldwide has to be understood within the physiological context of BJJ gyms. Few people practice BJJ with any regularity if they are lifelong addicts or alcoholics. The people being choked in those BJJ gyms are generally reasonably healthy with reasonably healthy physiologies. The three men who died in the choking cases I'm talking about here did not have healthy physiologies, but rather physiology severely impaired by lifelong drug and alcohol addiction. It seems likely that the non-harmful carotid choking effects seen in healthy BJJ participants would present as substantially more harmful, indeed arguably lethal, if applied to someone with an inherently frail physiology. Now, I'm no physician, but I suspect that these individuals with frail physiologies, when subjected to what would be a harmless carotid choke applied to a healthy person, that these individuals with frail physiology subjected to such a choke simply turn off. And of course, in the self-defense context, the person applying the choke that they expect to be harmless would be utterly shocked and surprised that this unforeseeable death resulted. Because the person defending themselves doesn't know the health history of the person attacking them. But these real-world deaths have important implications for the use of carotid chokeholds in actual self-defense. Lifelong drug addicts and alcoholics are overrepresented among the criminal class. This makes it more likely that a criminal aggressor whom you are defending against might possess a frail physiology. If you apply the same carotid choke technique to that criminal aggressor as you routinely do in the BJJ gym, as you were taught to do, with the expectation that it would be harmless, you might unexpectedly find that you've just killed that person, that aggressor with a frail physiology. Not so much because your conduct was inherently or predictably lethal, but because the person against whom you had to defend yourself was unpredictably physiologically frail. Should that occur, like with Mattioli in Wisconsin and Penny in New York and my own defendant in Colorado, you might suddenly find yourself charged with some combination of murder, manslaughter, and criminally negligent homicide. And this is especially true when the case can be racially energized because of a racial disparity between the choker and the choked victim, as is true in the Wisconsin and New York City cases I'm citing here. It's also worth wondering if this frail physiology, rather than police misconduct, wasn't the actual cause of death of Eric Garner in New York City back in 2014, given that Garner was morbidly obese and suffering from existing respiratory morbidity when he decided to violently resist police arrest. Or if frail physiology isn't the actual cause of death of George Floyd in Minneapolis in 2020. Floyd, who at autopsy tested positive for methamphetamine, had swallowed a whole bunch of pills when he was arrested, so they presumably wouldn't be discovered by the police, had 3 times fatal levels of fentanyl on board when he died, again, while violently resisting police arrest. Floyd also had 80% obstruction of his coronary arteries, no evidence of damage to his neck, and had just tested positive for that infamous death virus, COVID-19. Now, in the case of Garner, the police officer involved was falsely accused of using a chokehold. He did not. And in the case of Floyd, the police officer involved, Derek Chauvin, was accused of having killed Floyd with his knee, the knee suppressing Floyd's ability to breathe. Is that what really killed Garner or really killed Floyd? Or was it their own frail physiologies and their poor decision to violently resist lawful arrest? In any case, these political and legal risks associated with chokeholds, or even perceived or imagined chokeholds, suggest that perhaps alternative BJJ submission techniques rather than carotid chokes should be the go-to self-defense choice, since we don't choose whether or not our aggressors against whom we have to defend ourselves will be healthy or have unseen frail physiologies. Fortunately, BJJ is rich in such alternative techniques to chokeholds, including an almost endless list of ankle locks, knee locks, wrist locks, elbow locks, shoulder locks. And all these joint locks might result in a ruined joint if they were applied full force. Generally, you don't have to because the person gives up when they feel the pain of the joint lock. It's a compliance technique at that level without causing serious physical injury. But even if they were used full force, they might cause a ruined joint, which might qualify as serious bodily injury. Fair enough. But they are extremely unlikely to result in unexpected death, and therefore the risk of a murder or manslaughter or criminally negligent homicide charge. All right, folks, that's really all I wanted to share with all of you today. I'm sorry it's short. Again, the internet here is very poor. Over the weekend, I'm still here at S12, but Monday I start heading back on the motorcycle, and I'll be staying in hotels with better internet, and hopefully I can get some longer form content out to you on the travel home. With that out of the way, I'll just remind all of you that if you carry a gun so you're hard to kill, if you carry a knife so you're hard to kill, if you carry pepper spray so you're hard to kill, if you study jujitsu so you're hard to kill, I do all those things so that I am hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.